Welcome to People Care Health Services Community Connections. My name is Michelle Ray Meredith, and I'll be your moderator today. And I get to introduce you to our speaker, Ann McMichael, attorney, state attorney. And Ann comes from, or graduated from the University of Denver Stern College of Law in 2009. And she's been practicing law for about 7 years now. But what I'd like to know, Ann, is why estate law? Why did you choose that?
Thank you for having me, Michelle. Well, when I was 18, my father was diagnosed at a very young age of 47 with ALS, or Lou Gehrig's disease, which is a terminal illness, and it was incredibly shocking. And I recall sitting there with my parents when they would sit there with their social workers and their in-home healthcare providers being told, you need to get your estate in order, or you need to get your documents in order. And I remember them saying specifically, what are you talking about? And the social worker had no resources for my parents. And I thought, how frustrating. And I didn't realize that this is a common issue. And so when I became an attorney, I wanted to use my skills to help people and give them the resources they need to get their estate in order and obtain the documents that they need to make sure their wishes are followed all the way through until the end of their life.
Great. I'm excited to learn more about estate planning and that. Go on.
So these are just some of my credentials that Michelle went through. And my contact information is on the bottom if anyone's interested. Normally, this is a part of the presentation where I would ask for a show of hands, but we can't do that. So I thought I would bring in some statistics for everyone. 60% of U.S. adults do not have an estate plan. Of adults between the ages of 45 to 54, 62% are men, and 67% are women that do not have anything in place. And 55% of Americans will pass without a will or estate plan in place whatsoever. That's a large percentage of the population. I hear a lot of reasons for why people just don't care to have an estate plan in place. I've listed 5 of them there for you. And I have to say that I think they're all inadequate and, for instance, too time-consuming and too complicated. I promise you, these things, getting these estates in place can take maybe 2 hours of your time, maybe 3, depending upon the size of your estate and the number of people involved. Really, the work's on my part, and for you, it's just an initial consultation and a closing consultation, and it's really, really easy. And all of my clients have told me afterwards that they had a misconception that this would be difficult, and they were totally wrong. So I'm here to pass that message along. So who needs an estate plan? In my opinion, everybody needs an estate plan. But in particular, if you have young children, if you're married and have young children, you should have an estate plan to appoint a guardian and to make sure that your children will be supported. If you have a mixed family, if you are working on marriage 1 or 2 or 3, but you have children from a previous relationship and your spouse does too, you need to make sure that your children will get part of your estate. If you are in a second marriage and you pass away, your spouse doesn't, your spouse will get everything, and then they can turn around after you've passed and not give 1 cent to your children. It does happen. It's a horrible thing, but it happens a lot. And that's how an estate plan can help you get around that. Again, the third one, if you've been diagnosed with a serious or terminal illness, while I hope you've had something in place before then, if you haven't at that point, you really need to get all that paperwork in order and make sure your wishes are going to be followed. Not many people have this next one, but if you have an estate over $5.4 million, we can help you avoid estate taxes and pass on your hard-earned assets to not only your children, but your grandchildren and their children. And then finally, people think, oh, I'm single, I don't need to have an estate. If you are okay with your parents getting all of your estate, or if they've passed your siblings, then that's okay. But if you want your friends or other family members other than siblings or your parents to get a part of your estate, or you want to give anything to charity, you need to have an estate plan. So what documents are included in a estate plan? In particular, With my firm, CCRJ, we put 5 documents in. We have a financial power of attorney, your medical power of attorney, your advance directive or living will, your burial directive, and a will that may or may not include a trust. So we're going to walk through all these. The first one is the medical power of attorney. This is a document that allows you to choose someone known as an agent, usually a family member or friend, to make decisions on your behalf concerning your medical needs if you are temporarily unavailable to do so. So if you are ill and you are in the hospital, or if you are in a car accident and you are injured, that person will step in on a temporary basis to make sure the doctors know what your medical wishes are and are followed. And once you are well enough to make your own decisions again, that power is returned to you, and you can go on and make your own decisions. What's important to know about this document is this does not come into play when you are passing away like your other estate documents. This is separate. However, if you are incapacitated, that is not the time to execute this document. You will not be able to execute a medical power of attorney if you are suddenly in the hospital and can't make your own decisions. So the time to do so is when you are of sound mind and you are well enough to sign this document. Financial power of attorney is very similar to the medical power of attorney, but this allows a person to select a family member or a friend to make financial decisions on your behalf in the event that you are, again, ill or injured temporarily. These decisions can include making sure your mortgage is paid or your rent is paid, your utilities are paid for, your cars are paid for, etc. No one wants to get out of the hospital to find that their mortgage hasn't been paid and their car hasn't been paid, the utilities are turned off. I mean, what a nightmare that is to come home to. And so just having this document in place allows your agent to make sure that all of these things are being met and your life can go on smoothly when you return home. And again, this document is something that when you are ill or temporarily incapacitated, you cannot sign. So it's important to get this done before that would ever happen, should it ever happen. Does anybody have any questions so far?
Well, Anne, I was just curious, does all attorneys provide the same documents for an estate plan?
Not necessarily. There are forms that the Colorado probate court will provide to all attorneys, and then we format it for what we need or what our client prefers. That usually also includes a lot of terminology and legal jargon that you may not be interested in. But no, they're not all the same. All documents are not created equal, especially nowadays you can go on the internet to LegalZoom.com, for instance, and find versions of these. Sometimes these documents, although I would say they're a good outline, they may not guarantee that they include all the terms that are available to you per state. So that's why it's important to contact an attorney when you want to execute these.
Okay.
The next important document that's included in our estate plans is your advance directive, which is also known as your living will. This is a legal document that comes into play when you have been diagnosed, normally by 2 physicians, with a terminal condition, or you are in a persistent vegetative state. A terminal condition may not necessarily be that you've been diagnosed with a terminal illness, but it could be that, for instance, if you are diagnosed, in very late stages of cancer, and you've only been given, a few weeks to live, that's when this document would come into play. Not if you have years or even months to live. This is something that a hospice care provider should have and your doctor should have. So what this document is it provides your wishes for your desires to have be put on a ventilator, be given IV fluids, a feeding tube, if you want dialysis, if you want a pump for your heart. Those sorts of interventions, those medical interventions, are listed in an advance directive, and it's your decision as to whether or not you want those. And this doesn't necessarily have to say, I don't want them. You can say, I absolutely want all of these things forever. It's just a way of getting your information and wishes known to your healthcare providers for what you would like and how you would like to be treated until you pass away. You can create this document when you have been diagnosed with a terminal condition, or if you're in the end stages. The key, though, is that you have to psychologically communicate that you know what your choices are and what you're doing. This is something that is witnessed when you sign it, and those people will be there to say, yes, he or she knew the choices she was making when they exercised this. If you are not of sound mind, however, you cannot exercise this document. And I've had a lot of people ask me in the past, is a DNR or a do not resuscitate form and an advance directive the same thing? No, they are not. A DNR comes into play where, let's say, for instance, you are in an accident and you require CPR. If you have a DNR that says do not resuscitate, then CPR will not be performed. You are not necessarily terminal at that point. So DNR kicks in way before. Your advance directive is when, yes, you are absolutely terminal or in a persistent vegetative state. That's when the document kicks in. So if you have an advance directive and you were asked by a hospital nurse if you have a DNR, those are two very separate forms. Again, these are some of the decisions that advance directive includes, which is the acceptance of artificial nutrition, use of a ventilator. It also includes whether or not you want to donate your organs. So wills. Wills are the largest document in our estate plan and probably one of the most important. The will is the legal document that allows you to determine how you want your assets distributed. Your assets include your property, your life insurance, money, your vehicles, your jewelry, everything tangible and non-tangible in your home, within your reach. Your will can also include a guardian for your minor children and how to set up trusts for those children or someone that is disabled. Your will, again, can allow you to extend any assets you have, not just to your spouse, but to your children, to your grandchildren, and your great-grandchildren, and so on and so forth. A will is important if you want to make sure that your property goes to those family members, friends, or charities that you specifically designate. And you know, sometimes some of us have family members that we don't quite get along with, and if you want to make sure they don't inherit any of your property, a will is the way to do that. Continuing on with wills, again, this is, if you want your wishes carried out, you should probably put it in writing and have it signed and notarized, and it will be witnessed as well. There are multiple types of wills that we're going to go through in a minute, but again, if your will doesn't meet certain legal standards, such as those that can be provided on such as LegalZoom, sometimes they don't include all the legal standards, they can be challenged in probate court. And sometimes, as much as the court tries to uphold your wishes, if they're not legal, then the court's going to make decisions for you. So there are a couple of types of wills here. The first one, the testamentary will, is the typical will that I draft for my clients. It is in writing and witnessed and signed and notarized. This is usually, if it's done again with all the legal standards, this will hold up in probate court and to any challenge. A holographic will is a will that is in writing. However, it's not usually signed and notarized by witnesses. We see this where if you tonight go home and pull out a piece of notebook paper and you just write on there, I want all my stuff to go to my children, and you sign your name, that's a holographic will. It is not always held up in court, and that can be a problem. And the other problem is the importance of witnessing the will is so it can be said that, yes, these were the decisions this person made. I witnessed them executing this document. A holographic will, because it's not witnessed, sometimes people can lie and say, oh no, so-and-so drafted this document, here it is, right here, and forge it. And if there's nothing to challenge that, that can go through. So I don't recommend a holographic will, but if it can be upheld if you feel you need it, but normally it's not. And it is challengeable, and you will probably lose. An oral will. People do this once in a while. It's a spoken testament just to someone, you know, your spouse or your parents or your siblings, that just says, I want my assets, my car, my house, what have you, to go to so-and-so. That's great if your family's going to uphold that, and everyone you trust will also uphold that. Clearly, they're not widely recognized, though, in court. So I do not recommend them. So we already walked through some of this, but why do you need a will? You know, wills aren't just for giving your assets to your spouse. If you have a business or an investment, you need to make sure that a smooth transition from those assets are made correctly via a will. The will allows you sole discretion to determine how you want your stuff distributed. Wills allow you can bypass a spouse and give everything to your kids. You can bypass some of your kids and give it all to one child. You can bypass all of them and give it to grandchildren. Wills allow you to do a lot of things. I've drafted a few wills where a whole section was dedicated to the care of a pet. You know, we have pets, that's part of life, and you need to designate someone to care for your pet. You can give them money to do so. You do it in a will. Again, most importantly for a will, if you have minor children, a will allows you to select a guardian and set up a trust for your minor children so they will be cared for. If you have children from a prior marriage, this will allow you to make sure that your children receive a distribution outright from your marriage, from your assets. If you want to give something to charity, do it in your will. This happens a lot. But if you don't have a will, the state's not going to make that decision for you. If you pass away intestate, nothing's ever going to go to charity that way. So if you are charitably inclined or you want to leave something to your church, what have you, you need to do it through your will. So again, I just mentioned if you do not have a will, you will pass in what is known as intestate. And in that case, the probate laws of the state that you pass in will kick in and oversee the distribution of your assets. Usually that includes filling out a form of all the assets by someone you trust, hopefully, and that will go to the court, and they will oversee how that's going to be distributed, whether you have a spouse, whether you have children, grandchildren, what have you. So if you don't have a will and you have a larger estate and you want to avoid tax consequences, if you don't have a will, that's not going to happen. And the federal and state are going to take their hefty share of your estate. We can avoid that stuff through the creation of trusts and a will. So that's always my suggestion. Again, that's only right now, the federal estate tax is at $5.4 million. I understand not a lot of people have that. But if you want to pass a good chunk of your estate onto your children instead of the federal government, get a will. And finally, I've had some people ask me if the state would inherit my assets if no one stepped forward. No. There's not a gigantic account in Colorado for people that have passed intestate and none of their family came forward to collect their assets. They will sit. Your assets will sit, unfortunately. Usually what happens if someone dies intestate, they can put out an ad in the paper. It sits for 30 to 60 days that says this person has passed away. If you know them, come forward, which means that anyone who knows you can come forward and claim some of your property. And if that was not your intention, then you should have a will. Get to the next slide here. Okay, so if you pass away without a will, you are intestate, and the intestate formula will kick in. And this is what the state uses, what the probate courts use to decide how to distribute your assets because you did not have a will. Sometimes half your estate can go to your children and half can go to your spouse. Once in a while, let's say you have adult children, this can result in the sale of property, and that can, of course, negatively affect someone living in that home if all the parties who are going to collect from your estate do not agree on how to distribute property. So if your second wife and your children from your first marriage do not get along, they can go to the court and say, you know what, we want you to sell the house and sell it out from Dad's second wife, and we want half. And that can happen. It's unfortunate, but if you don't have a will, the court gets to say what's going to happen. Obviously, this can create financial and emotional issues, and if you have a will, you can hopefully bypass those issues for what already is a very stressful time anyway for your family and friends dealing with your loss. Because again, unfortunately, I see nothing brings out the worst in people than money being on the line. And this is what's going to happen. So if you have a will, you can avoid that. Finally, if you don't have a will, but you have minor children, and if both you and your spouse pass, what will happen is the court will designate a representative and a temporary guardian for your children. Clearly, as a parent, you want to be the one to make the decision as to who would watch over your children and raise them for you. If you don't have a will and a guardianship in place, then the court's going to make that decision for you. The court doesn't know you. They don't know your family and children, and they get to make that decision. So to protect your children, you should have a will with a guardianship designation. The process, if you do not have a will, to find a guardian for your children can take months, especially if you have multiple people coming forward who want to raise your children and act as guardian. It can take many months in an already incredibly emotional and stressful situation. So take that stress off, as sad as the situation would be, and get a will. Some people already have a will, and they want to know, can I change my will? Some people think once I have a will, it's in stone and I can't change it at all. And that's not true. I always tell my clients your will is a living, breathing document, and changing it is really easy. If there are a lot of changes in your will, if your spouse has passed or you remarried and you have multiple kids now, we'll usually redraft a new will for you. If you just want to make a small amendment, you want to add that somebody's going to get a certain part of your property, we just do what's called a codicil. It's one page. It's just added on to your will. It's really easy to do. I can usually do them. If someone calls me at 8 in the morning, I can have it done by noon. It's a really simple process. No one should think that their will or any of their estate documents are in stone. You can always change these documents. So some people require a trust, which is a document that is usually incorporated into your will. And a trust is usually created if you have minor children, and should something occur to you, this would be, your assets would go to a trust for your children, unless you want your 8-year-old to inherit a large chunk of money outright. Most people don't. So we create a trust. We also create trusts for grandchildren, people with large estates numbering over 5.4 million, and that sort of thing. Trusts, there are a lot of types, but the terms are really unique to each individual. They're not set in stone. There's usually 3 entities involved with the trust. There's the trust maker, who would normally be the person who has the will, who's creating their will and a trust within that will. That is the trust maker. The trust maker can also distribute their assets into the will, or into the trust, excuse me. The trustee is the person that will actually oversee the trust and be responsible for making distributions from the trust. And finally, there's the beneficiary, who are the people that will receive the benefits or distributions from that trust. For example, the trust maker in this case would be a parent. The trustee would be the designated guardian, and then the beneficiary would be the children. So there are a couple types of trusts. There is something called a living trust, which is created, as it sounds, when you are alive by the trust maker. And it is also referred to sometimes an inter vivos trust, which is a Latin term. And it just means that it's created and started and what we call populated during your life. And populated means when you actually put assets into the trust. And it begins functioning as a trust and something that distributes assets. Prior to that, if you just draft trust terms in a will and it's not actually created, it's just terms. It doesn't truly exist yet. Most trusts go into play when the trust maker has passed, and these are called testamentary trusts. Testamentary trusts are formed by the executor of a will. And that is when it's created normally, and then when it's populated by whatever your assets are from your estate. Below that, there are 2 categories of trusts. There is revocable and irrevocable. Revocable is exactly how it sounds, which means once the trust is created, even if it's in place, you can remove what's in the trust and you can change the terms of the trust. You're not locked in to the actual trust and the trust terms. These are usually for living trusts, and the other purpose is if you're creating a trust for someone with a mental handicap, a minor, or to avoid probate. It is a fad right now to put a lot of your assets during your life into a trust. Your house, your money, everything. Trust, car, everything. I say up front, that is a lot of work for people to change your deeds, change your titles, everything. You can remove things from the trust and it can go in and out. It's just very expensive and very time consuming to create up front. On the back end, once you pass away, it can be much easier and you can avoid probate. However, whoever is your trustee at that point will still have to distribute everything from that trust. And again, it's a fad. I don't recommend it for most people, but if it's something you are interested in, that can be time consuming. But
and we have a question.
Sure.
And the question is would that trust work if it's a Medicaid situation? They're wanting to protect their home and give it to someone else instead of the state.
Not a revocable trust. That type of trust, and I think that's the next slide actually. I get that question a lot. What you want to create in that situation is called an irrevocable trust. Normally, if you're trying to avoid Medicaid, you need to do this 5 years before you would actually need Medicaid, which most people don't know when that's going to happen, but Medicaid does a 5-year look back. So if the year before you tried to create an irrevocable trust, they would still say, nope, those are your assets, we're going to count them against you. So an irrevocable trust is where you would take a chunk of your estate and put it into a trust that once it's created, the terms do not change and you cannot get back whatever asset you have put into that trust, which is why after 5 years, Medicaid cannot consider it. You are also not a beneficiary of that trust. So this is, in a Medicaid situation, if you took a chunk of your estate, put it into an irrevocable trust, made someone else trustee, not your spouse, And basically, you're really setting it aside so you can leave it to your grandkids, something along those lines. But once it's created and populated with money or property, it's irrevocable. You can't take anything out. You can't change it. Again, like you said, we use a lot of those for Medicaid. And they're great if you can afford to put something in them that you don't plan on needing in the future, like money. If you can take a chunk of change and just say, okay, I'm going to do without that money that's going to go to my grandkids or whoever, that's great. The point is, the beneficiary of that trust cannot be you when you are considering a Medicaid look back. I think we covered everything on that. Oh, I should say, an irrevocable trust is also used when you have a large estate, over $5.4 million, and you want to pass that on to your children to bypass taxes.
Yeah.
So there are multiple types of living trusts that are both revocable and irrevocable, and really these are just designed to meet an individual's situation. There are some things you can do for trusts. You can have a life insurance trust, which you just put your insurance policy, the beneficiary is that trust, and it is a way that you can pass on a life insurance policy to a beneficiary and avoid taxes on it. A lot of people do it, especially, you might not have $100,000 sitting in an account right now, but someday that might be something nice for you to leave to your child or grandchild. A special needs trust is for usually someone who's disabled, whether it's a minor or an adult. That is going to require income, and you can set these up so you can avoid canceling out your Medicaid or your Social Security. There are many, many different types of terms you can put into a special needs trust, and they're really great for helping out a disabled beneficiary. Finally, a spendthrift trust, it was a really common term a long time ago, but really it's just a trust where whoever is the trustee can make whatever decisions they want to regarding distribution of those assets. I think the biggest thing I can tell people is if you want a trust of any type, please have an attorney drafted for you. Because if it is not in accordance with the probate laws for that state, it will not be upheld. And these are just some sources that you guys, if you were interested, can go look at, and there are tons on the internet. But again, if you are really interested in having someone draft this stuff for you, I highly suggest seeing an attorney who is familiar with the probate code so you can avoid any challenge that might come, and so your will stand the test of time.
So at this time, we'd like to open it up for questions. I have one already for you, Anne. What is the difference between the living will and the 5 wishes?
The advance directive, I think, is made more in advance, like it says. I think it's a little less personable than your 5 wishes form. It really centers around if you want artificial nutrition or to be on a ventilator or life-saving medical procedures if you are found to be terminal or in a permanent vegetative state. I know your 5 wishes has it's a little more personable, like I said. You can decide on music, or if you want some articles of your possessions with you, or your dog with you, or certain family members with you. The 5 wishes form is more personable. I think the only other thing, though, I don't know if the 5 wishes document is considered a legal document, and so your advance directive as a legal document would be upheld in court.
And we had another question with the internet, and you were talking about oral wills. What about a video will?
A video will may be something that is upheld. I think timing of it could be an issue. If it were witnessed, who those witnesses were is important. Again, if you made it but you were not of sound mind at the time you made it, that I could see that being an issue.
Okay. And we have another question here. Apparently, if you have a DNR, your family can supersede your decision. Is there a way to ensure your DNR wishes are respected?
Well, I would, in that case, you could couple it with an advance directive. Your DNR should be upheld, but it is unfortunate. Anybody can make the decision in their power of attorney or their advance directive to have one go over the other. So in that case, your agent would have the final say for how you wanted to be treated. I would suggest selecting an agent for these things that will respect your wishes, period. I know it can be a really emotional time when you have to use these forms. And even though if you're drafting these forms at a time when there's no stress and that, an illness or something is not an issue, that's great. But things are very different when suddenly you're dealing with an emergency situation and people panic. So if you want to make sure your wishes are carried out at the end of the day, that can be done through an advance directive. Additionally, you should always make sure your medical treatment providers have copies of your powers of attorney as well as your advance directive, so they are aware that those documents exist. People ask me, what if I'm in the hospital for an emergency? Your hospital should contact your primary care physician, who can then tell them they have a DNR and an advance directive and a power of attorney on file. And those are also documents, however, that whoever is your agent should have copies of, because the hospital will not respect those documents unless they see it in writing. That's probably beyond your question, but...
Let's say that I do write out my will and I have it signed. I'm leaving it there as a holographic will, and it comes into play. When do I, if I was alive, when would I have to worry about someone taking it back to probate and challenging what was in there if it's not a true will?
Normally that would not come into play until you pass. And we find, sadly, that very quickly after someone learns that a family member has passed, some people you may not want to inherit from you crawl out of the woodwork. And at that point, your family member would have to quickly run to the courthouse and have that will registered with the court. So the court would acknowledge this is the first will we got. It can be a first come, first served thing. So if someone behind your back drafted something that they said was your will, and they got there first to the probate court, that will might win. So it's really important to have a will that is an actual legal document, signed, witnessed, notarized by an attorney at least. But usually your challenges will come in right after that person has passed away.
While we wait for some more questions, Anne, can you share with us what makes your law firm unique?
Sure. We honestly, Michelle, we don't believe in charging people a lot of money for these documents. We've done a lot of research on what other firms charge, and we just think it's too much for people. These are really important documents, and people should have a right to them, no matter how much their income is. We offer payment plans at our firm to help you out. If you don't need an entire estate package, like what I've just discussed, we offer what's called a la carte menu. If you just need a power of attorney quickly, we can do that for you. And we also will offer in-home consultations for those who can't come to our office. We understand that can happen if you have an illness, or if you just suffered a stroke or you were in an accident. We can come to you and draft those documents with you. We have a mobile office, and we can get everything done with you in your home if necessary. We'll provide witnesses and a notary. And I think that's what makes us different, is we try to show our clients that we actually do care about their situation and that they should have access to these documents no matter what.
Do you write a special needs trust?
I can draft a special needs trust, yes. Really, special needs trust is a kind of a generic term. What I do is normally look at the individual who would be the beneficiary of that trust and look at what their income sources are, Medicaid, Social Security, that sort of thing. And then I go from there with the terms. There are a lot of things you can do. There's the ABLE Act and that sort of thing. And then we look at what are the terms that are best available for that individual.
Okay. And can you discuss issues and solutions around getting a will in place where the mental capacity of a person may be in question?
Sure. You know, what I normally do is during the initial consult, I kind of get a grasp for where that individual may be mentally. I understand through some of these things, working with Alzheimer's and stroke patients, that there are different times of day when you might have more clarity. I try to meet with that individual when they're having more clarity during the day. I meet with them usually multiple times and go over the documents with them and the terms as many times as I need to feel like that individual has understood it. There are times in the process where I feel like at the beginning they understood what they were getting into and what we were drafting, and towards the end they may not. That doesn't mean we can't execute that document. If I felt like that individual understood those terms at some point and they weren't being coerced by someone, by a family member or something like that, then we can go ahead and execute. Sometimes it's as simple as asking, getting an understanding from that person of if they understand who's the president, what year it is, how old they are, what month it is, that sort of thing. In some cases, if I really don't know, I can talk to a family member, have them come with, or you can send them to specialists who can do an evaluation and decide, yeah, I think he or she gets this. I think they're coherent enough to understand this, and you could probably go ahead and execute.
When's a good age to start planning an estate plan?
I would say when maybe your 30s or 40s, if you have children, absolutely. When you have children, you should absolutely have one. It kind of depends on your situation too. If you're single but you are estranged from some of your family and you don't want them to inherit from your estate, you should probably get a will. And again, I think beyond 30 or 40, everyone should have one. We all, unfortunately, we're all going to grow older, and we may at some point, we're all going to experience an emergency at some point, probably. When at least the powers of attorney might kick in, and we're all going to get old, and at some point we will need these documents. But I would say really based on your situation, but in your 30s or 40s, I think, when you definitely need to start, especially if you have a family.
And another question is, if you're a shopaholic and you're always purchasing new things, and it could be just simple trinkets that you want to leave behind and you're starting that plan, do I need to run to my attorney to have them change my will every time, or can it be added to something? How do we?
No. All of that, even after you've executed your will, falls into your estate. That's an asset that you have. The question would be if you want something specific to go to someone specific. We give property lists for that reason. If you pick up a new item and you want a niece or nephew to have that item, you just write that down on that property sheet, and then that will be included in your will. And you can do that after you've executed. You don't need to change your will or do a codicil or anything like that.
What if I want to leave, have my older friend be my executor of my will, but he may perish before I do? what can I do in that sense?
Normally, we tell people to pick a primary and a secondary, just to avoid that situation. You can go beyond that. We usually try not to, but we always have everyone for all of those documents actually that we discussed today select a primary and a secondary.
Okay.
And playing off that question a little bit, you can choose some people out of state. If you have family out of state that you would prefer make decisions or be your executor, you can absolutely list them as a potential executor or an agent.
Okay. Well, we'll just give it a couple more minutes to see if there's any other questions.
I realized, Michelle, I forgot to throw in a slide on burial directives. A burial directive occurs after you've passed, and it's just a way to share your wishes with your family about what you would like done after you pass, from your cremation, burial, music you might want played, a funeral, where you want to be buried, how you want to be buried, if you want specific people invited to your funeral, passages that you may want read from a book, something like that. It's just a kind of a check sheet that we have created that allows our clients to make those wishes known to people.
And is that something still unique to your law firm, or?
It's not necessarily. Some places don't do it. It is a form that is offered. It is not, though, it isn't within the Colorado, we call it the Orange Book of Documents. It is, but we've added a few other things to it based on requests we've received from our clients throughout the years. People are going from, transitioning from, a lot of people used to want to be buried to now they want to be cremated, or even their body donated to science. And all those options, everything we could think of is an option on that burial directive. So your family would have it after you've passed and know how to plan and how to say goodbye to you and to make sure your wishes are met.
Excellent. Well, Anne, it seems that I think we're coming to the end. There is no other questions at this time. I want to thank you for your time and coming in and sharing this important topic.
Thank you so much for having me. I'm happy to spread the word.
Definitely a topic that we all need to be proactive on. Thank you, everyone, for joining us. This will be once again recorded and uploaded on our website for later viewing. And please note that the slides have been available for you to download. So thank you for tuning in, and until next time.